the worst you ever represented?
Murder. And I won the case.
Ooh, look at you. I believe you. I'm scared. Murder.
Yeah, murder.
Is it okay, Rochella, a lady at work? Hey, how are you? You're looking good today. Is it okay for me to do that?
So if you are my direct line manager and Wanshela, that would usually most times be deemed as sexual harassment. So that is why relationships in the workplace, in most workplaces, are strictly forbidden because of this situation.
King David Studio Podcast.
We have with us Nthabiseng Dubazana of Dubazana Tennis. Today, different subject matter altogether. Because I realized that I'm not taking advantage of all her knowledge and skills. Because I'm cholo. So today I decided, let's talk about other stuff that you're interested in.
Yes.
Mewe, how are you today?
I'm well. How are you?
Thank you so much for coming.
Thank you for having me.
We've indicated before that you don't only deal with divorce law, divorce cases, you deal with law as a whole.
Yeah.
One of them is criminal law. You said you enjoy it. Yes. Good for you. Good for you. What's the worst you ever represented? No names. Crime. Theft.
Murder. And I won the case.
Ooh, look at you. I believe you. I'm scared. Murder.
Yeah, murder.
So obviously you were defending.
Yes, I was defending this poor guy, and I do say poor guy.
Yeah.
It was the deceased was apparently one of those guys that steal things from other people, but he was like he had taken refuge, so to speak, under my client's home, but then he stole from my client. And then when my client found out and whatnot, he got hold of him. Of course, he beat him up.
Yes.
And then
out of anger.
Yes. And then he went with him house to house where this deceased sold all these.
Oh, collecting.
Yeah. And then the funny part is that when he did that, the whole community was like, finally somebody is doing something about it. So they beat him up.
Wow.
So the community.
So it was one of those mob.
It was mob justice.
Mob justice, yeah.
So my client was the one who eventually was like, "Hi guys,
we have to stop.
You know,
we're going to kill him."
You know, and then took him to the clinic where he was eventually certified dead.
Oh no.
So they wanted to pin the entire murder on my client.
On one person.
Yeah. So, I tried to negotiate with the state so that I made representations so that, we can, and they're like, no, they're adamant to proceed with the murder. The trial took 45 minutes. And it was done.
Beginning to end,
45 minutes, and I was done.
That sounds impossible. Even what is this GBV? What is it with aggravated what?
No, people. Some cases that are in the public eye are necessarily long. They really don't need to be that long.
Oh, there are some cases that are not long.
Yeah,
just the ones we see on TV.
Yeah, they take too
7
long.
months.
Take too long. 45 minutes. I was done with the trial.
And he was out.
He was so happy. I was so happy.
I can only imagine.
Because the magistrate was like, I remember when I was done, when the state was done with their witnesses, they had 2 witnesses. Defense, I'm like, Your Worship, I'm going to apply for 174. Granted, Mrs. Dubazana, I didn't even have to lay any.
174 is we can, with all we have, we can make a judgment.
Yeah, we are saying that you must acquit him with everything that you've heard from the state thus far. And then I didn't even have to give reasons why I'm applying for 174. I'm like, Your Worship, I'm making an application for 174. Granted, Mrs. Dubazana, sir, you're free to go. Next. And that was the end of the case. 45 minutes.
Wow.
Yeah.
Jeez, that's now you're going to get people who have committed murder who want you to represent.
Oh, don't do it.
Anyway, I want to talk about labor as an issue. A lot of people get fired.
Yes.
For all sorts of reasons, good or bad. Some make sense. But I will ask general questions, and allow me, because I want us to educate more than anything. People do all sorts of things. Let's go at the low-hanging fruit, sexual harassment.
Yeah.
It's a common one. People end up in those situations quite a bit. Is it okay, Rochella, a lady at work?
Usually.
This is common. I say, hey, how are you? You're looking good today. Is it okay for me to do that?
That is a bigger no than a yes answer. So if you are my direct line manager and wanshela, that would usually most times be deemed as sexual harassment because it's from a senior to a junior. And it doesn't matter if the senior is male or female, as long as it is from a senior to a junior, it is deemed as sexual harassment. But if we are colleagues on the same level and all of that, and you decide to have a relationship, if one shell and I'm not offended by it in any manner or form, asking you why are you looking at me in that manner, if we decide to have a relationship, it's always advisable to go to your line manager and inform that there's a relationship happening here. And then the best option is usually to separate you, not in the sense of firing somebody or whatever, but let me move you from this department to that department so that you're not in the same.
You're disrupting the functions of a company.
And also, just now it goes south, and then now there's going to be other issues because you're now in the same work area and all of that.
Yeah.
But it does happen that some people don't get moved because there's nowhere else to be moved, and then they end up getting married anyway, and then they continue, and then
everything is fine.
But as long as the line manager is aware of this, so that tomorrow it shouldn't be an issue where one of us now lodges a sexual harassment case against the other.
I find sexual harassment to be quite a gray area.
Yes,
because you like it, you're happy with it, and it continues. It's not sexual harassment. Put that aside, that scenario aside, and create a new scenario. You don't like it. My actions are exactly identical in scenario A and scenario B. The person who's receiving the shela is the one that's experiencing it differently.
Yes.
Scenario A, they like it. They're happy with it. They like me too. Scenario B, don't like me at all.
Yeah.
I'm harassing them. Why is that the case, that the one can be sexual harassment and the other one not? Or is it that obvious?
No, it's not that obvious. Sexual harassment truly is a gray area because what, like you said, what appears okay to one person may not be okay to the other. So that is why relationships in the workplace, in most workplaces, are strictly forbidden because of this situation. So if it so happens that one shela and I tell you no the first time, and then you persist, then it's ikala indula jwang. Then it now falls within the ambit of sexual harassment because I said no to you and you keep coming, which means you don't understand the concept of no. Also, sexual harassment can go. I've heard of situations whereby you looked at me in a way that made me feel uncomfortable.
My daughter.
You know?
But I don't know.
And then Otolo, that's what the person said. I don't even remember this day that I looked at you in this certain manner. You were undressing me with your eyes. You were all of those things, you know? And then sexual harassment obviously can go also to the actual touching of somebody, you know?
Slapping
the butts and all of that. Or even hugging me when I don't want you to hug me. Why are you in my personal space?
I didn't know. It was whoa.
You know? So it is
quite the first and only hug.
Yeah. It is quite a broad spectrum. So that's why each company usually has their own sexual harassment policy, that these are strictly what we deem as a company to be sexual harassment.
You want a hug?
Yeah.
Yes.
Anything within our work premises. It's also happened that what you do outside of work comes back to bite you.
I was about to say, because I immediately, when I was saying that you want a hug, do it, go strutting, I realized that maybe not.
It has happened that
colleagues,
we fight somewhere out there,
not even
on
close
a Saturday,
to the premises.
You know, we're not even working or whatever. But as a result of that fight, the person who started the fight, gets dismissed. And because I am bringing the company into disrepute, because people can associate me with Mashabela entertainment and all of that, and therefore you get dismissed and all of those. So, and things you put on social media,
it's another
is another thing, can also come back to bite you.
We've seen
business.
a lot of people get in trouble
Yeah,
for that.
yeah.
That
So
one.
we need to really be careful how we conduct ourselves in our private and workspaces.
I get a sense, and this is just a general sense about us South Africans. We think we know, and yet we know very little.
Yeah.
And I think this is another area where we know very little about, and that's why we end up in trouble. Sexual harassment, again, let me go back to it. And I'm going to get unnecessarily technical, bear with me. Slap on the wrist versus slap on the face. It's a gentle, hey, show me, versus hey, show me, versus hey, show me on the side, versus hey, show me on the butt. Surely different slaps are different.
That is true. But like I said, each company has its own situations. But even if a company has its own situations, how I feel as the person at the receiving end of those touches and slaps and whatever could fall within the ambit of the area of sexual harassment of that specific company. Or even if it doesn't, it can fall within the broader definition of what sexual harassment is in terms of all these cases that have happened in the labor courts and all of that. So just don't.
Just don't do anything.
Yeah, just leave people alone so that you don't find yourself having to deal with unnecessary disciplinary hearings about that. You may be vindicated in a disciplinary hearing, but do you really want to go through that trauma and emotional stress of preparing for a disciplinary hearing based on a sexual harassment case?
Any case, any law, any rule, because people will take advantage of it. That's just life.
Yeah.
And we had scenarios where people take advantage of sexual harassment and wanting to get Nthabiseng fired.
Yes.
And I say, you undressed me with your eyes. I still find that tricky. I don't know how it's proven in court, but yes. Have people taken advantage of it?
Yes, it has happened a lot. I know of one case whereby the senior manager in the situation was female and wanted the male, and then the male was not interested. I'm not sure if the male was married or not, but he just was not interested. And as a result of being rejected,
the female is being rejected. The boss is being rejected.
He is being rejected. Then she opened a case of sexual harassment because he's male. It's obviously going to be, unfortunately, going to be a lot more believable that he would have made a pass at her and all of that. But in the end, the truth did come out and he was vindicated and he continued to keep his job. They just removed him from that department. I'm not sure.
I wonder what is the punitive.
Yeah, I wonder what happened with her.
What are the punishments?
Yeah, I don't recall what that was, but he was able to come out with the truth and show that he did not do anything untoward to his boss. And that was a problem for her because now, she's now been
embarrassed. And yeah.
Something
you said in telling that story, that it's more believable when men do it than it is women.
Yeah.
How well entrenched is that state of mind in the system? And when I call the system, I say in the legal system.
Yeah.
How well entrenched is that statement that men are likely to do sexual harassment acts than women?
Sadly, the statement is truer than fact.
Okay.
Right?
Okay. Give us.
So,
yeah.
Because men are physically and otherwise dominant or ought to be more dominant over women, it is easier to presume that they are the ones, for example, assaulting, raping, and all of this.
Yeah.
So it is the same within the work environment. That what do you mean Nthabiseng is the one who's hitting on you?
It doesn't even make sense.
Doesn't make sense, And also, if what's
wrong with it? It's fine.
You see,
why is it a problem?
A big deal?
Yes.
That is the attitude that we come across and we deal with, and then having to break that down when you're representing a male person is the hardest thing to prove anything. When you're representing a man in court is such a lot of work.
And it goes down to even a GBV, I imagine.
Everything.
Yeah.
Children's court maintenance,
You name
everything.
it. Yeah.
It is so much harder to prove that dad or the male
is the victim.
Yes.
Of what?
Of all of this that is currently that brings us here in the courtroom.
But is the legal system as a whole aware of this challenge that the male has in most of these cases? I'm basically asking, and I'm probably asking a much more deeper question in my head that says, if we know this statement you just made now, are we the only ones in this meeting that are aware of it, or is everybody else aware of it, particularly those that matter, judges and all of that?
It is known, but I don't think the judges take judicial notice of it, because there are some things that are general public and we're like, the court has judicial notice on this. You don't really need to go in depth about that. Because if you're going to say that, then it may seem like you are nullifying or belittling other cases whereby women are going through so much hell because of men and all of that. And yet, I mean to say, it is also true that a lot of men are going through the most because of women,
yes.
So it is known, but it is on the hush-hush, if I can put it that way. Just every man needs to know that your battle is your own. It is time to, you're going to have to work hard. And if you've got a female representing you, oh my gosh, it goes to court because how dare you as a woman when you
defend a guy who is in court for suspected having done something so bad to a woman.
Yes.
Hey.
Yes.
And then the magistrate is a woman.
Born from
more,
bad to worse.
It's more complicated.
Yes. Yeah.
You'd rather have a woman defend you and a magistrate who's female if you're truly innocent.
Yeah. Because then they'll be able maybe to see through if you are the lies and detect.
True.
Because as women, maybe we'll be able to go like,
And also your story is more believable if you are found not guilty.
Yeah.
By a woman judge and a female defendant as the defending attorney as well. Wow, this is interesting. All right, let's go back to it, because now it's criminal law.
Yeah,
I realize that. Now, some of the most common challenges that people have at work is being dismissed unfairly.
Yes.
In America, you're fired. Donald Trump made a thing, because we've seen that since we were young, that they just tell you you're fired and you leave.
Yeah,
it's not the same, because we have rules. Actually, probably in America they have rules, but for some reason on TV we see the simplified version of that. Give us some of the, and it's tricky to ask when the law is so wide, but touch on some of these things that a person got fired for stealing, as an example. The procedure or the process of that. Give us an example. Using that example, what happens? Whether I was caught stealing or something disappeared and I'm suspected to have stolen it, what should be the common process?
So, you are now being charged with theft.
Yeah.
Once that is done, they need to issue you a notice for a disciplinary hearing. Right?
Okay, one.
That's the first step. Yeah. They need to issue a notice of that. Or rather, they should do their investigation first.
Yes.
Right?
Before they issue
with the notice.
Yeah.
So that once they have conclusive proof that you are the alleged person to have committed this crime or this theft in work, then they issue you with a notice for a disciplinary hearing. It should not be less than 48 hours. So that it can give you an opportunity to prepare your defense. So that notice also is your charge sheet. So it will have that on this day you allegedly did 1, 2, 3, 4, and as a result you're now being charged with this and that. You are allowed to bring a colleague as a representative. You are allowed to bring a union representative, but you're not allowed to bring an attorney in a disciplinary hearing. It's an internal procedure.
Okay. Right? An attorney is not part of us.
No, it's not part of us at this stage. And then thereafter you're allowed to also bring witnesses and all of that. And then it is basically...
Are they allowed to do the same? Is it almost like a court?
Basically like a court, but very informal like.
Okay.
And then they have to get an independent person who doesn't work, even if it's within the same company, but doesn't work in this specific branch and works in a branch somewhere.
No vested interest in this.
Yes, in this situation. Yeah. Get an independent person who will then sit and hear the matter.
Let's pause there.
Yeah.
This person's independence is a bit troublesome for me when I hear you say it. How independent? Who's getting this person?
It's usually the employer.
How
Because they've
independent? How independent is this person?
Oh, they have to be. They have to be very independent. I've said in one disciplinary hearing as well, being hired by the employer, and then you listen to the merits of the case at the end of the day.
No. I'm probably saying if I'm the one that's organized the party, I'll probably determine what music we play.
I hear you. I hear what you're saying.
It's my party. I'm paying for it.
Yeah.
So how independent is this person if they are invited by one of the parties, and the party in this case is the employer?
Yeah.
You get where
I hear what you're saying, but unfortunately, they are bound by ethics. But not that it works all the time, but they are bound by ethics to be impartial.
Yeah.
So that you can give a ruling that is
fair.
That is fair. Should it go to the CCMA after that, it can be upheld.
That's
you
it.
know?
Yeah.
So that is where it usually goes from there. Once the disciplinary hearing is done, and then if the outcome of the DH is let's dismiss, then the employee has the option to now take it to the CCMA. And if the ruling is I give them a final written warning or whatever, then that's that, and then life continues.
It's fine, yeah.
Yeah.
Because it's almost like a punitive measure following the disciplinary hearing that says, it's a final warning.
Yeah.
Let's talk about the warnings. How many do we get?
It depends on each company, but usually you get a verbal warning, and then you get a written warning, and then you get a final written warning.
What if I don't remember the verbal warning?
It is recorded. It may not.
Okay.
It may not be. You may not sign for it, but it is recorded in your
that
work
he
history.
received a verbal warning.
Yes, it would be in your portfolio at work. It has to be.
Yeah.
Yeah.
So there's verbal warning.
Then there is a written warning, and then there's the final written warning.
That's quick.
Yeah.
Shouldn't we have another one? Moves like it feels like the trip is too short between the verbal and the final.
If you misbehave that quickly, then yeah.
I guess.
Yeah.
Do they expire?
Yes, they do. Companies have their own different expiration dates for each. Usually verbal warnings are between like 3 months they expire, 3-6 months.
So I'm back.
You're back to
zero.
To zero.
Wow.
And all of that. Final written warnings take a longer period to expire because it means that offense was that serious. That it warrants that it should hang for a long time. It's like in criminal law, they give you a suspended sentence.
Oh, it's pretty similar.
Similar.
Okay, final warning is similar to a suspended sentence. Sorry, you as
Be
far
careful.
as should you trip,
then
it's enforced.
Yeah.
Wow.
Yeah.
It's quite interesting this final warning. But again, I feel we need the third one. It must be a verbal text. We need more, but that's just me. I'm nicer than that. And you say different companies are different codes.
Yes.
Of ethics, or what do we call them?
Code of conduct.
Code of conduct, of course. Different companies have different codes of conduct, but they must all be governed by something.
The basic conditions of employment.
Yes, they can't just exist.
Yeah. So yours cannot be too much. It cannot go over and beyond the basic conditions of employment.
Give us one simple example of a basic what's that? What is it? Basic
condition
of employment.
So conditions of employment is to make sure that your workplace is healthy, it is productive, and it is safe. That is the basic of basic.
Yeah.
I cannot now be dismissed for complaining that there's no toilet for me to use.
Okay.
You know what I mean? It should be that there is sanitary areas for me to be able to function. I should be able to have an hour's rest, which is the lunch hour.
That's it.
I should be able to have time off, which is leave. I should be able to have maternity leave. I should be able to have paternity leave. And all of these things should be afforded to me. They are just the basic
as
things.
Part of this thing that I'm doing for you.
Yeah. These are the things that are allocated to me. I should be able to have a way to lodge a grievance against you as my line manager or employer because you did not conform to my what is required to make me as your employee as comfortable, as minimally comfortable as possible.
I imagine even labor union representation.
Yeah.
It falls under basic.
Yes, it is.
Yeah.
Yeah, because you are entitled. If your sector has a union, then
You're
you're
entitled
entitled
to be a
join
member.
that. I cannot be threatened now that if I join the union, therefore there's going to be repercussions for that. It's not permissible.
However, they are still, what we decide as a company still can't be outside this.
Yes.
Has to be within this. There must be, I probably want to use the word reasonable in all of this. If can a company be completely unreasonable in their code of conduct,
Yes.
where they come up with something that just doesn't make sense? We've seen them with COVID.
Yeah.
We've seen where they stretch it and see how far this thing will go, where we say, if you're not vaccinated, you lose your job. So how common is it, particularly in South Africa, based on your observation, that companies will just want to test the labor law?
Very much so. Even outside of COVID, companies that just don't want to conform to anything in terms of the LRA, which is the Labor Relations Act, and people working in such conditions that you don't understand how you are even functioning. People working 7 days a week. That means
No break.
there's no break. When you want leave, it is a whole issue. You're being threatened with suspension or dismissal and all of those things. And then came COVID. Now there's this whole scary disease that is out there. People want to protect themselves, understandably so, and all of that. But remember, the LRA, when COVID hit, had not developed to cover such things
not at
because
all.
it didn't exist.
Nothing existed.
What happened was that government was throwing in policy after policy
As they were
going. And then companies were like, okay, no, let us take this policy and adapt it to the work environment, not conforming to what the LRA is
Already
saying and what the
says.
basic conditions of employment are saying. And then if you didn't want to vaccinate, then you get dismissed. Now we're dealing now in the realm of the constitutional law, my rights to
make my own decision.
Exactly, my own medical decisions, my right to my bodily integrity, and all of those things. Those things are now still going on, being challenged because there is no specific law that says one has to be vaccinated.
Is there supreme law above all of them? Is it the
It's
Constitution?
the Constitution.
Which gets tested all the time. That's the beauty of democracy, I guess. Gets changed, it gets debated in Parliament and then the Constitutional Court and so forth and so forth. Because I look at it and say COVID allowed us an opportunity to see a lot of things that we're probably not exposed to. That one, the law is an evolving animal.
Yes.
Which changes all the time. And I guess it brings me to this point where things that is the labor law just as adjusting as all these other laws as well, because it can easily stay the same for a long, long time. Because what else happens in labor in labor scenarios?
No, the labor law is evolving with everything because work situations change.
Yeah, working from home now.
And now we have to adapt to that. And the law has to change with regard to that. As to whether the LRA itself will change is yet to be determined. But what the labor courts are doing, making sure that they now pronounce on certain things. And then if the constitutionality of it is questioned, then it is taken to the Labor Appeal Court, which sometimes eventually ends up in the Constitutional Court.
Yeah.
So the constitutional part of everything can be pronounced on and it can be made law. So I think that is where we are at now. Most matters are yet to get to the Constitutional Court for it to actually be made law. Right now, we're just still in the realm of CCMA and Labour Court. Yeah.
Do we have an effective CCMA?
Our CCMA is overwhelmed. It's inundated with a lot of things. Already prior to COVID, it was a problem.
Busy, yes.
Now, post-COVID, it is a mess. Because there are so many unfair dismissal cases as a result of the period of COVID, and so many retrenchment cases. Section 1, is it 189?
Section 189.
Yeah, Section 189 situations. There's a lot that is going on.
COVID led to companies not being able to make money, and some closed and some didn't, but
didn't.
pretended they were reducing staff because of COVID and so forth. Yeah.
So there's a lot that is happening there. And commissioners also during COVID, they got slashed. They got removed.
Oh, really?
We don't have a lot of permanent commissioners in the CCMA. We have a lot of part-time commissioners. So that is already
How would they do that?
Because they couldn't afford. They couldn't afford to pay commissioners anymore. When COVID came, it became a lot. And with the number of cases that were coming on, one commissioner dealing with 20 cases, and then their fee, it skyrocketed.
Yeah, then it got even heavier and heavier for the
commission to be able to pay.
Here's another one, which to me is similar in some small way to sexual harassment. Insubordination.
Yes.
In simple language. It's relative, in my opinion.
Yes.
What I say to you, that's how I was raised. That's what we say. There was a defense here, Advocate Dalimpofu, about shut up. Where he said he won. That's exactly why I bring it up. Shut up can be seen as rude. The defense was not in my language. In Zulu, Tula. Is not heavy, is not offensive.
Yes.
Mamela is not offensive. But in English can easily be translated as being rude. Shut up.
Yes.
And I look at it and say there's a lot of relativity in those type of debates. Then what happens, particularly insubordination as a factor?
Sure. Insubordination is a tough one. I'm actually dealing with one now. Insubordination, I think it would determine on the conversation and an objective person having a look into it. So if my line manager is saying that I was being insubordinate, I was insubordinate toward him or her, then a third party would have to come and listen look at it and decide whether or not it falls within the ambit of insubordination. And if that is the case, then we can proceed with disciplinary hearing, etc., etc. There is a case that was decided recently in the labor court.
Okay.
This guy was dismissed for lying. I'm going to this because of the language situation. He was lying to the company because he went to go bury his mother twice and then went to go bury his
He had mommy one and mommy two.
He had literally his father was married to two women. His mother did pass. Second wife, Mamnganwaki, died. So he had to go bury his mom because he was raised by both.
I guess I am right. There's mother and mother.
Yeah, exactly. And then his brother had passed on and left a child. And then his child also had died at some stage.
Jeez.
So when he went to go bury this child, then the company is like, no.
You buried two mothers.
Yeah, now you're burying two sons.
Yeah.
What is going on?
And we know you to have only one son.
Yes. And then they dismissed him and then it went all the way to the labor court.
Whoa.
The CCMA had said that the dismissal is unfair as a result of the translation and dynamics.
Yes.
And the labor court is like, the workplace can't be so obtuse not to understand that this country is so dynamic and diverse that these things happen. And then the order was not only reinstatement, but with back pay from date of dismissal. So
you wish you could reinstate the stress.
Yeah.
Like take away the stress that comes with that.
Yeah. And so it goes back to the way you speak, because even if you were to say shut up in this tone and you receive it as offensive, a third party listening is going to like, but she wasn't even shouting.
It wasn't a big shut up.
You know, exactly.
No, it wasn't that.
Exactly. If it goes to that way, then it falls within the ambit and area of insubordination.
But we have to agree still that the relativity of it is so huge. Because you'll have to go through that. And I like that you say it only an independent person.
Yes.
You know, is it those moments where we talk about the reasonable
man test?
Yes.
Yeah.
Or what would anyone think of that conversation? There's something that has to be said about things that are immediate dismissible. Remember I said we are exposed to this as South Africans because we have so much American television. You're fired.
Yeah.
We've seen it. Do we have immediate dismissible things, offenses in South Africa?
I think so. In this, I'm saying think because, like I said, each company has their own rules and reasons why this would specifically be
dismissible.
Dismissible. A few months ago, there was a case, the Nando. I don't know if you know about the Nando's case. This man was dismissed immediately for having eaten carrots at work. So when it went to the CCMA, the commissioner had him reinstated with back pay. Now, the issue, what he had raised as a defense in that he didn't deny that he ate carrots. What he was saying is that because we freeze our food, and then when a client orders soup or those bowls, Nando's, the carrot tends hot pot, then it remains frozen. And then the client will return it and complain about these things. So what he did was take one carrot out to make sure that it's not frozen. So that the client should not complain. The commissioner asked the employer a question: is that, do you know how the working of this store works and all of those? Is these things true? Yeah, they've happened before, but he shouldn't have. He should have rather told his line manager. And it's like, is there time when a client has
waiting on the counter
to tell a line manager that, wait, it is possible that this carrot is frozen? The answer was no, and that is how he ended up
getting his job back.
Yes.
Wow. Yeah. So going back to my question that says, are there dismissible offenses, immediate dismissible offenses? I guess according to Nando's code of conduct,
that was immediately dismissible.
Yes, but in any other company, they say, you have to, like in a restaurant, and I use this not necessarily a fast food restaurant where you will taste quickly before you serve. That could be allowed. Yes. For example,
when a chef is cooking, a gourmet meal, like it's good. Or is it too much salt or whatever, and all of that. Those things in that scenario probably are allowed, but here it is not.
Here, the law. It's tricky.
Very.
No wonder you find it fascinating.
Yes.
Because there's so much about it that you still to discover.
Yes, you cannot not know everything about the law. Every time you do something, you find something new.
Code of ethics. Does it play a role in that space?
No, ethics is usually for professionals.
Yeah. Oh, yes, a professional body.
Yeah.
But explain that. Let's talk about code of ethics.
Let me talk about attorneys. Yeah. We have ethical procedures that we need to follow. If you follow, like for example, the Dalimpofu situation, other attorneys other people in our field felt that he broke ethic because that is not how an attorney should conduct himself. And then it had to go to the LPC, which is our body that governs us, the legal profession council, whereby they had to assess, looking as a third party, if that behavior, looking at how it ended up to where it was, whether he acted unethically or not. And then sometimes that would lead to either you in that professional body being suspended,
those words,
and all of those things, and not being able to practice the law going forward.
I guess it's similar to the example with Nando's. Different bodies would have a different, I imagine, for doctors, and it's very different, and so forth and so forth. Yeah. And still governed by the common practice of how you conduct yourself ethically. You can't walk into a company usapara completely naked. All of those, you still have to be within the ambit of normal human relations.
Yes, definitely. There was a case I did, also a labor matter. This guy was dismissed based on a doctor's note who never even examined him. So this doctor looked at another doctor's note and said, man, this guy should have been able to come to work. And as a result of that, he was dismissed. So this man went to the HPCSA, which is the governing body for doctors, and then lodged a complaint against the company's doctor and saying, how do you give a conclusive medical opinion when you've never even examined
this based on
somebody else's examination? And then he was fined like 10,000 rand or something like that. I'm not sure.
The doctor
for doing what he had done. But still, even with that, the company didn't even reinstate him. So in CCMA, he still lost the case irrespective of something like this.
There was a punitive measure on one side,
Yes.
but on this side, he didn't get his job back.
He didn't get his job back. So it was still yet to go to the labor court. We never got that far. I don't know whether he found another attorney or not. But, these are the kind of things that when it comes to ethics that we need to be careful of as professional people.
As South Africans, as ordinary folks who, want a good life for themselves and their children, are they looked after by the labor law, labor courts, and so forth? Is it a space that we can comfortably rely on?
Yes, it's just that we need to know more about it. I've discovered that people don't even know how the CCMA works, the rules about it, the time periods, and all of that. You can't be dismissed today and then 6 months later you want to go to the CCMA.
Yeah, you're too late.
You're too late. You have to apply for condonation and all of those things. And when you go to the CCMA, you are able to be given that advice, that you know what it is that you need to do
by the CCMA,
by the commissioners and people there in the CCMA. And then also on the CCMA website, there's those forms that you know that you can fill in for unfair dismissals. You can download them and be able to fill them in yourself and all of that. Parties don't even know that certain matters automatically you can get an attorney. It's not all the time that you get an attorney in the CCMA. Okay. Sometimes attorneys have to apply to represent you because not all cases warrant an attorney. Because the CCMA is supposed to be it should be shorter than litigation. So it is viewed that when attorneys are on board, we take long because we want to litigate.
Of course.
So the aim of the commission is to try and reduce the time that this matter is being heard. It shouldn't be dragging and all of those. Get an outcome as soon as possible. And if that outcome is favorable to you as the employee, great. But if it's not, then you can now acquire an attorney to go take it further to the labor court. Then, that's where all the litigation can then happen. Yeah.
People get dismissed, they lose a case or they win the case. And in the dismissal, there's say 3 months, 4 months of pay for having, gone through all of this, and would rather give you money than have you back in the office and all of that. I'm sure there's scenarios like that where the case, whatever happened is not necessarily irrelevant for my point, but we end up in this moment, but we don't want you back. And we are happy to give you money.
Yes.
And is there a reasonable amount of months that you would say this is a reasonable amount of months of salary that you could give someone?
The maximum you can get is 12 months.
The maximum
you will get 12 months compensation.
Yes.
So what happens when you get to the CCMA stage now? You have a date for CONARB, so conciliation / arbitration.
Yeah.
So usually they start with the conciliation first, which nobody except the parties are allowed in the room with the commissioner. And then the commissioner is trying to mediate to see if the people can come to some sort of settlement. And if the parties agree that, you can go back to work on this condition. Or like you just said, I would rather give you 6 months pay. I don't want you back in the office. If they accept that, the commissioner writes a certificate, it's over.
Done.
Right?
Yeah.
But if that fails, then we go to arbitration. Arbitration is now the actual hearing of the matter. But even before the arbitration happens, on the day of arbitration, conciliation is attempted yet again.
One more time.
Just to see if there's
still room. It's like that divorce matter.
Yes. Is there still room to try and settle this before we start this long journey of arbitration? And if parties are able to agree and all of that, then that's that. Usually when it's in conciliation stage, you can get 4 months payment, 6 months payment. It's very rare that a company does give 12 months just to say, we don't want you back, but then the commissioner can then, if you win as the employee, then they can award you up to 12 months compensation.
But of course, case by case,
yes.
Depending on what the merits are. We exist now in the gig economy with freelance and so forth and so forth. How protected are freelancers within the realm of the labor law in South Africa?
You are, because remember, you have a contract at the end of the
year. Yeah. Which one are we protected by? Is it it's a contract of employment, I
Yes.
guess, or contract? The agreement is that you will offer a service to me
Yes.
within the following rules.
Yes. So it is a contract of employment at the end of the day, be it for 3 years, be it for 12 months, it's
Or
employment
2 days. Yes.
at the end of the day. But the only difference is that usually freelance people in entertainment or wherever, they earn 30,000 and above, usually, not all the time.
Of course.
And as a result, you don't fall within the ambit of the CCMA.
Okay.
It's the same as legal aid, for example. Legal aid, if you earn beyond a certain amount, they can't represent you because you're deemed
to be able to afford it.
So
yeah.
the CCMA is not the area for people who earn that kind of money. They don't have jurisdiction to hear that. So the matter will then be going straight to the labor court as a
Okay.
result. So that's where you'll
I
be
didn't know
able
that
to
that's
argue
what
those things.
CCMA.
Yeah.
It doesn't cover everybody.
Yeah, it doesn't cover
So some CEO who got fired
Don't go
by
to
the
the
board
CCMA.
can't go to CCMA.
Yeah, don't go to CCMA. Some bargaining councils do. They work in the same realm as the CCMA. They do hear matters where people earn such monies, and then from the bargaining council, if you don't win, then you can go to the labor court. But that's if your area of work has a bargaining council that
Yes,
deals
that's-
with these things.
That's another thing.
That's
Not
another
all of
thing.
them have a bargaining council.
Yeah, otherwise we go straight to the labor court.
I employ a freelance. I need you to come and cut my lawn for the next 2 days.
Yes.
We agree that I'll pay you 250 rands a day. We're good. It's all verbal. You come do the work. I find that you cut my flowers as well, and you were not supposed to. I'm quite upset. And I fire you. Day one, I don't pay you. I'm quite upset at what you did. I don't pay you. What options do you have in that very simple one? And I'll tell you what really my question is based on, is that there was no paper.
Yeah.
Remember when I said gig economy, you said contract of employment. There's no paper. It's just a phone call between the two of us. What happens then?
You can still go to the CCMA.
Yeah.
Most of the time, in that situation, garden people and domestic help don't have an employment contract.
There's no paper.
But they are covered, and they can get the help they need from the CCMA. Now, what you do is prove that by way of, if it was verbal, telephonically, and all of that, you would have a phone log, for example. See, this is his number. He called me on this day, and this is the conversation.
But are they protected by the labor system, the labor law, labor court system?
Yes, indeed they are. I mean, that's why the basic employment wage gets increased. It's because of such
They are
people.
recognized.
Yeah, they're recognized, and it is known. It is common cause that they don't have employment contracts most of the time.
So the law knows that.
It's known. So that's why once you are aware as a domestic that you are supposed to be getting a minimum wage of this amount, also you're supposed to be registered for UIF.
Leave days.
And all of those.
Hours,
entitled
hours.
to all of those things, So your gardener, your employee, your domestic employee are subject to the same basic conditions of employment that everybody else is. So now, without paperwork, it is a matter of just presenting this to the commission or the commissioner when you go to the CCMA. So it's giving the history and showing all of these things that have happened to prove that there was in fact an employment contract verbal between the two parties.
And I've delivered service. I wouldn't have delivered service if there was no verbal communication.
Yes.
Foreign nationals in a similar scenario with work permits, I imagine it's the same applies.
Same applies. As long as you are one obviously legally within the country.
That's it.
And then all of those, everything that every South African is entitled to, so
You're
are
also
you.
entitled to.
Yes.
I have a feeling this is another one that can be a live broadcast.
I think so too.
Yes.
Yeah.
Because I've worked for one company all my life, so my experiences are quite limited.
Yes.
I have a lot of references of people who got suspended and yet they hadn't done anything. And they stayed home for a long time, getting full salary, but of course frustrated.
Yes.
Because the future is unknown and human beings operate with certainty of some sort. And I remember these people, eventually they got to CCMA and they won the case. Does it happen that one party will drag their feet so much that it frustrates the process at CCMA?
Yes. So much. Not only at CCMA, but also at the labor court. So let's say the employer loses at the CCMA. Now they institute the review proceedings to review this decision near the commissioner. And then they just lodge the papers and do nothing. And it's silence for 2 years for no reason. Now you as the employee, most of the time, people don't know that they have a right to approach the labor court and say,
Kind of getting that phrase, justice delayed is justice denied.
Yes. And say this person or these people have been dragging their feet. They want to review. And in the CCMA, I was awarded 12 months. I was supposed to have gotten my 12 months pay. 2 years has now passed.
I'm still waiting.
Do something. The labor court has actually done something. A company had dragged its feet for 11 years. And then when the employee finally got some education and knowledge on what it is that they're supposed
11
to do
years
after
later.
11 years. The court was like, net for Daidin, you will pay not only what was due, but for all
the 11 years.
Yeah.
But justice, they'll never pay back the frustration.
Yes.
That's what I always think of.
Yeah.
As much as you're happy to have gotten all this money.
But it could have been avoided for the past 11 years.
And the frustration of uncertainty of work is the most, it'll drive you mad.
Yes.
Who knows? You got divorced, they'll never get your wife back.
Yeah.
Hey.
Yeah.
Wow. We're going to have a live. Yeah, this one, where we'll open it up to all of you. You'll ask as many questions as you want. Have you done any of that?
On
Even
radio.
on TV or radio?
On radio.
On radio,
Mostly
yes.
on do I name them?
Yeah.
Okay. On
Yeah, we're
SAFM. On SAFM on what's her name? Is it Chaba's
Yes.
show?
Okay.
She does a lot of that when it comes to the family
Oh, yeah, of
law,
course. There's
and
a lot.
also a little bit of labor as well, where people call in. I did 1 year labor not too long ago, 3 weeks ago, I think, and there were so many voice notes and so many calls.
Of course.
And then so many emails came after that, people inquiring. Some things were like 10 years old. I'm like, 10 years is too far. Like, I can't do anything
No,
now,
of course, yeah.
But yeah, no, I do those a lot with SAFM and Power FM.
We'll do live one of these days. People will be looking at you. Will send us messages. Those messages will be scrolling on our screen as well. We'll see whether we do it on YouTube or on Facebook and YouTube. Never know. So we get to. I think it'll be exciting to get to do these things, because I realize that my world experience on this subject, it even embarrasses me. Because normally I know a lot about things.
Yeah.
I know enough about things to be able to conduct a conversation. But I realize that about labor law, I'm quite... Even I can feel that. Anyway, thank you so much, Mebar. Well, I was able to conduct an hour-long conversation. Yay, give it to me.
It was supposed to be 30 minutes.
It was meant to be 30 minutes. Anyway, ke a leboga, man. Let's do this. We'll talk when we arrange the live.
Yes.
If you want it, tell us in the comments. Yeah. I now acknowledge the comments. It's not my thing. But I realize that people comment.
I'm scared of the comments. They scare me.
Do you know what? There'll always be someone who doesn't like something.
Yeah.
That's just life. I learned that very early in my radio career, that when you switch on the mic and start speaking to an audience of hundreds of thousands of people, there's no way everybody will agree with you.
True.
It's not possible.
True.
And you're hoping that person that doesn't agree with you is not violent in their disagreement. Always open-minded enough to kind of,
Engage.
go look at it and so forth. But you get people who just don't like it. They don't like the shirt you're wearing. The most common one I get is that I disrupt my guests. Kind of gotten used to hearing that one, and many others. But we move on. So let's chat soon, man. And Nthabiseng Dubazana, check out. We'll leave a lot of the details where you can get hold of her. But it's info@dubazanatennis.co.za. There we go. Thank you so much, everybody. Take care. And please don't get fired. Don't look at her like you're undressing her. That one frustrates me. Because I don't know how is.
I don't know how it looks either.
I have no idea.
No.
I'm looking at you. Am I undressing you?
I don't think so.
That's my problem. And you find that I was.
Ooh.
You see? We don't know.
Exactly.
That is for me, that's the biggest frustration about that one. But anyway, insubordination go tell. You know how tell. I think I've experienced that as a boss. Anyway, let's do this again soon. See you, everybody. Thank you again.
King David Studio Podcast.